Hello everyone, my name is Dmitriy Aristov. I'm an attorney in Los Angeles, California. I run my own practice under the name of ARISTOV LAW PC. As part of my legal services, I offer estate planning advice and document preparation for my clients. And since I started my practice, I've prepared dozens of estate plans for my clients and have received nothing but positive feedback since. You can always reach out to me at www.aristovlaw.com or call my office at 424-259-3550. So what is an estate plan? Well, an estate plan is a set of legally binding, signed, witnessed, and notarized documents that provide instructions to your personally selected and trusted individuals on what to do with your real property, with your accounts, with your cars, with your pets, with your social media accounts, etc. And also what medical decisions to make on behalf of you in case you are hospitalized, incapacitated, or in case you pass away. What documents are part of a typical estate plan? Well, there are four major documents that are part of a typical estate plan, especially in California. The first one is the Advanced Healthcare Directive. So the Advanced Healthcare Directive is a crucial document which gives your selected agents the power to make medical decisions on your behalf. It allows them to sign consents and releases with hospitals and doctors with regard to your medical care in case you're hospitalized or incapacitated. It also acts as your living will for end-of-life decisions. This document is required to make decisions for your healthcare by those that you may nominate to do so for you. The second document is a living trust. So you should think of a living trust as a company that you set up for yourself by yourself. You are the trustor, you are the person that creates the living trust, and you are the first trustee, which means you are in charge of administering your estate for your own benefit, for your lifetime. So when you are the first trustee, you fund the trust by transferring your accounts, your real property, and other assets into the trust. That way, you control the trust and grow it during your lifetime. And you have complete control over the assets that are in that trust during your lifetime. Once you pass away, your selected trustee will take over your duties as a trustee to settle your debts, handle financial affairs, and eventually distribute your estate according to your wishes, and then close out your estate in the end. The third document is a will. Well, a will is a document that states who gets what when you pass away. Modern wills are commonly referred to as pour-over wills. And the reason for that is that they're usually connected to a trust that you have set up alongside your will. So when you pass away, the possessions that are not yet in the trust pour over into your trust through this will. Now, if you have just a will and not a trust, the will is subject to probate, which means that it's subject to a court proceeding in order to make these assets get distributed according to your wishes. Unless, of course, there are certain exceptions that can apply in order for some of these assets not to have to go through probate. But these exceptions are narrow and limited. The fourth document is a durable power of attorney for management of property and personal affairs. It's a lengthy document that gives general power of attorney, which is a document where you name a person to manage your trust or non-trust assets in the event of your incapacity or absence. So this document gives your nominated person broad powers to dispose of, sell, convey, and encumber your real and personal property, but only according to the terms that you outlined in your document. So you may ask yourself, why do I need these documents? Well, I can name at least 10 reasons, and I will go through them on this video to help you understand that these are very, very important documents, and not having these documents really puts your assets at risk. So the first reason of why these documents are so important is to avoid a probate proceeding and avoid probate court altogether. So when you pass away, banks, creditors, companies, your heirs, your family members, and friends, they need a legal right and permission to take over the management of your properties, bank accounts, etc. Otherwise, these properties and bank accounts, credit cards, whatever it may be, they accrue debt or are completely neglected. So furthermore, there's unfortunately often significant disagreement over what to do with your assets and how to use them. And if you don't have any documents or instructions in place, no one has any legal proof that you meant to transfer your assets to them, or in the alternative, did not mean to have any assets to transfer to them in the first place. So the state of California, to ameliorate this problem, they set up a default estate plan for you. So that default estate plan is called the Probate Code, which is a set of laws created by the state to help you distribute your property when you pass away. However, unless you qualify for some limited exceptions, the court must and will distribute your property according to these laws. And the problem with these laws is that the California default distribution according to these laws is blind to your wishes. It's a public proceeding. It's very combative, and it's extremely costly. And furthermore, it's very, very lengthy. So I'll go through each one of these issues one by one. So the first one is that it's blind to your wishes. That is, the probate code really distributes property like a robot. I think fair is a hopeful word, but blind is really a better one, because debts must be paid immediately. Everyone gets an equal share, only according to your family structure. So regardless of what your wishes are in terms of who gets what. And there are no provisions for anyone else. Furthermore, this is done through a public proceeding where all of your real estate, all of your bank accounts, all of your assets must be listed and submitted to court in order the court to make a decision, and a proper decision, on what to do with your assets. A lot of clients do not prefer this, as they hold their assets in confidence and want only certain members of their family or trusted people to know about what money they have where and how much. This process is often contentious and very litigious, and I think it's obvious why. Since the creditors want to get paid and are knocking on your door, and your relatives want to share, your friends want to claim and say that he promised me X or Y or Z, and all of them are bringing their lawyers to this fray. Furthermore, there's a substantial part of your estate that will be lost to pay the costs of these proceedings, and substantial and mandatory attorney fees. The fees are often into the tens of thousands of dollars, and they're mandatory and are taken out of your estate first. That means that attorneys and court fees get paid first for any of these proceedings. Since they are a percentage of your estate rather than a flat fee, say $500, since they're a percentage, these fees can grow to enormous proportions. And at the least, 1% or 2% of your estate goes to payment of these fees. And if your estate is sizable, these fees are enormous. Furthermore, the executor appointed by the court is also entitled to fees, if there is one that's appointed. And those often mimic the statutory fees for attorneys, so even more fees that you have to pay out. Finally, the probate proceeding takes months, if not years. It's not uncommon for probate proceeding to take 10 months. And during that time, the problem is that nobody has access to these assets, or they have limited access to these assets in order to continue your businesses, in order to pay your debts, in order to pay out the people that are supposed to be paid out under your wishes. And this is often devastating to your successors, who may depend on income from some of your assets to continue living their life. So far we're only on reason number one of why you should have an estate plan. And that reason is to avoid probate court and probate proceeding at all costs. So how does an estate plan help you with this? Well, having a proper estate plan circumvents this process altogether. The way this works is that once you create a trust, you transfer your assets into that trust, and then all of the assets become part of that trust which means that you personally don't own those assets anymore. What that means is that at the time of your passing, you as an individual don't really own anything, and therefore there is no need for a probate proceeding to determine what to do with your assets, since everything is in the name of your trust. So instead, it is your trust which specifically outlines who gets what, when, and how, and your successor trustee distributes the property according to your specific wishes. Everyone walks away, probate is avoided. This is such a powerful tool that this type of trust is called a probate avoidance trust. Think of it better as a government avoidance trust. Simply put, proper estate planning documents do everything possible to avoid the probate proceeding altogether. So the second reason to have an estate plan is to remain confidential. So because trust documents are not submitted to the court and there are no court proceedings, the assets, their character, amounts, and other distributions are not made public. They're not subject to public scrutiny and not subject to certain mandatory disclosures of accounts and assets. The third reason is to save money on taxes. Your successors will benefit from the tax breaks and capital gains savings specifically that are given when property is inherited or transferred through a living trust, and may save thousands and thousands of dollars by doing so. Accountants regularly suggest transferring property into a trust for this purpose specifically. So the fourth reason is to have full control over who gets what and in what amount. The most important part of this control over distribution of your assets is that you might want to give everything equally to your kids, or you might want to give them something to make sure that they're taken care of, but leave the remainder donated to your favorite charity, for example. There are many different ways you can make a decision about who gets what and when, and you have full control over it, unlike you would if you went to the probate court and done it through a probate proceeding, which again distributes only according to your family lines. So for example, also, you may want your children to be provided for in a minimum amount. And maybe you also want your grandchildren to be provided for in a minimum amount, so your children don't spend all your money just on themselves. So you may also want to give a specific item or a family heirloom, like a car, a piece of furniture, a watch. These are all things that you can outline as specific gifts. Or let's say you may want your pet to go to a specific friend who's better equipped to take care of that pet. Remember that when you don't have these documents, the property will simply pass on according to the state's default laws. In addition, your instruction can protect beneficiaries from themselves. For example, if they have issues with alcoholism, drugs, gambling, etc., putting someone else in charge of these finances while they work out their issues until they resolve the issues acts to protect them from themselves. Now, the fifth reason is to have full control over who can potentially be disinherited, which means that they don't get anything. Remember, the default laws in California distribute according to your family bloodlines. But for example, if you are falling out of favor with one of your family members, under the default laws, they're still going to get part of your inheritance. You may not want that, and maybe it'll get fixed in the end, or maybe in a year or so, you guys will make amends. But until then, you should have something on paper and clearly outlined about whether somebody is supposed to get something or not. An alternative reason, without any judgment at all, is also that some people are already well provided for. So maybe your money and your assets better serve their purpose to somebody that is more in need versus the person that is already happy with what they have. The sixth reason to have an estate plan in place is to make sure that all your guardianship nominations are done correctly and ahead of any potential issue with your health or your hospitalization. So that means that if you're a parent, these documents will provide for a nomination of a guardian for your minor kids. And barring this nomination, children will go to a default family member who may not be favorable or cannot be found. Or worse yet, without these documents, the child may go to the foster care, which is handled by the state, and you certainly don't want that for your children. The seventh reason is to designate someone to make healthcare decisions if you are incapacitated or hospitalized. If you're hospitalized or incapacitated and cannot speak or act, healthcare workers, doctors, and surgeons must get certain permissions for your medical treatment. They can't get it from you. So they will be at a standstill if they don't have any documents showing who may make these decisions on your behalf. In fact, they will be at a standstill if there is disagreement about what kind of treatment you should get. So furthermore, the wrong people might make these decisions for you, somebody who does not have your well-being in your mind. In addition, if you don't have any proper documents in place, your family members might be forced to go through a conservatorship proceeding in order to be able to make decisions for you and for your assets. So these can be very costly and very complicated and should be avoided at all costs. Reason number 8, to provide instructions regarding your remains. These instructions give you the opportunity to specify how you wish to have your remains dealt with. That is, maybe cremation or burial, or to provide details of any prior arrangements and to designate the persons to carry out your wishes. This is especially important to bring closure to your children and beneficiaries at a time of mourning, as they often appreciate given clear instructions on your exact wishes. Reason number 9 is to update your existing will or trust. If you have had a significant change since the last time you signed any of the above documents that we mentioned, the Advanced Healthcare Directive, the will, a trust, or the power of attorney, you might have changes in your life that affected how these documents are operative now. That is, having children, getting married, or acquiring new property that is not yet in the trust name. Your previous documents may no longer be effective and may no longer distribute the property according to your current wishes. So if you have changed your mind about certain distributions, this would also be a reason for why you should update all of your documents. Reason number 10, and finally, and perhaps most importantly, is to have a peace of mind. Having an estate plan in place will reduce at least some of your stress about your future and the future of your children and grandchildren. When you plan, you take control of your future and the future of your assets. When you plan, you diminish needless disagreements between your children, grandchildren, friends, and other family members, and as a result, help them move forward as well. So your appointed trustee can actually resolve these conflicts on your behalf by having clear instructions of your intent during your lifetime. And furthermore, this is a plan that can be clearly communicated to your family now to set expectations going forward. Many of my clients walk away with a feeling of relief and happiness after they sign these documents, and many of them always wonder, why didn't they do this earlier? And I sympathize and understand that. So finally, you may ask yourself, is an estate plan right for me? And what do I do next? Well, if any of the above information that I outlined perked you up, or you put a mental checkbox next to one of these reasons, then feel free to contact me. I am available at 424-259-3550, which is my business phone number. You can email me at dima@aristovlaw.com. You can visit my website at www.aristovlaw.com, where I have a list of other helpful resources about estate planning. And you can contact me directly to ask any of the questions that you may have about estate planning. I would be happy to talk to you. I also created a checkup quiz on my website. This checkup quiz asks you questions that you may not have asked yourself before and helps you guide yourself in determining whether an estate plan is something that you should look into further. And this quiz is available under my website, under my areas of practice and estate planning. And as always, I wish you the best of health and prosperity, and I look forward to hearing from you if you have any questions. Thank you.